So on Friday agenda today, so our first presentation actually is the CMO Fiduciary Responsibility and Transparent Age of AI, with Mark Stouse will be leading that. And I got a feeling this one's going to have a lot of discussion points to it. Yeah. Because I was shocked when Mark brought this back to the to our marketing organization practices team. Everyone was just kind of shell-shocked, and it took us 2 meetings to actually start to digest this. So without further ado, I will hand this off to you.
Thanks, man. Okay, good morning. So let me just start by saying that even the craziest part of what I'm about to show you is true, right? One of the things that's really important is to do your research and triangulate things as much as possible. What you're going to see, even the stranger parts, okay, are really factually accurate. You can take them to the bank, right? We are entering into a completely new phase because an action like Delaware 2023 is coinciding with all forms of AI, right? As well as increased risk in the marketplace, which would normally spur more shareholder lawsuits anyway, right? And the 3 things together, plus some additional stuff on the peripheral edges right now anyway, is really spurring this along in a major way. So a lot of people are really surprised too, because they're like, I haven't heard anything about this, right? And this happened 2 years ago, January 2023. It did get a lot of coverage at the time, and then it kind of went dark. Most people feel like it kind of went dark because the whole topic of fiduciary duty was always seen as very rarefied, boardroom level kind of stuff. Didn't really come across any normal person's path, with any frequency. And also it takes about 2 to 3 years for anything like this to kind of take hold and begin to move in the system. SOX is a great comparison, right? But it was legislation. So you could see it coming, you could do something about it, you could get prepared. This was literally an out of the blue decision by the Delaware Chancery Court. So to put this in perspective and why this is like really meaningful, we're talking about 90% of venture-backed companies in the United States of any size are Delaware domiciled, right? So fall under this law. Roughly 2/3 of the Fortune 1000 also fall under this law directly. Yeah, there are some moves to move. Like Meta might want to move to Texas and things like that. But also what they're doing is that they're doing kind of a dual domicile corporation, which is unlikely to be successful for them in shielding them. So, all right, so let's just take some of these points, right? So effective oversight. So what we're really talking about here in this ruling is that the court said, number one, the way that fiduciary duty has always been defined is too up there, right? In other words, the bar for proving breach too high, right? Because you essentially always had to say, you had to be able to prove the guy or the person did it on purpose, right? So now you can just be stupid, negligent, incompetent, whatever, okay? And that's enough. Which is that in of itself is huge. They also said it's impossible in the current business environment for the board and the CEO to deliver their fiduciary duty to shareholders without the full support of all officers in the company. So they extended the fiduciary duty of oversight to all officers, including individual accountability, individual liability. So now as my dad used to say, the cheese is getting a little more binding, right? And it's just it's one of those things where this is so huge that it's you can't take it in. It's kind of like what Frank was saying. You can't take it in all at once and fully appreciate it. So this is kind of like a primer. This is designed to help you get started. So this means that effective oversight, right, in your area, marketing, for example, it's not just an operational issue anymore. That's kind of like largely a matter of opinion, largely a matter of did you reach certain goals and objectives and things like that. It's actually a fiduciary risk, right? Now, it's really important to say this. You are not suable, okay, if you fail to meet a goal. That's not what this is. But if you go into an organization, let's say you're the new CMO in some organization, but this could apply anywhere in a company, right? And you're kind of getting your arms around the reality of that situation, and you don't sit down and immediately start to assess and document your risk factors, and then start to say, okay, this is what we need to do in order to mitigate these risk factors, and it's going to take this amount of time and this amount of money, and you document all that, and then you send it to, well, the procedural requirement is you have to send it to both the CFO and the general counsel as a notification of major risk, fiduciary risk, and then they have to decide whether or not they're going to fund it. If they don't fund it, it doesn't remove fiduciary duty from you totally, but it makes a huge dent in it. You'll probably effectively transfer about 90% of your fiduciary duty in that situation to them. So there's going to be a little bit of gotcha being played here in a lot of these companies where, hey, I told you about it. I can prove it. You made the decision not to fund it. Monkey is on your back, right? Okay, let's see here. Okay, so negligent oversight can now lead to personal liability, even if there's no provable intent or damage. So I was just involved as an expert witness in a case in California that with a Delaware company that never went to trial, and it was all about CRM data quality. So it was extremely narrow. During discovery, they got permission from the judge to compel the introduction of a software that's widely used in the financial services industry to pattern match for fraud indicators and put that onto the CRM. The results were every bit as bad as the meme around CRMs would ever suggest, right? And given the fact that this problem literally was provably, not just anecdotally, ascertainable for 16 years in the system, okay, meant that the reason why I didn't have to do my job is that the company caved immediately and settled out of court in a sealed judgment. But I can tell you, without telling you anything else, it was $30 million, okay? And part of the payment came from the CIO, the CDAO, and the CRO's personal liability insurance policies. So that's I think, very emblematic of where this is going. Okay, so I'm a little ahead of myself here, but this is a case in point, but you know, it could be literally anything. I mean, the next, say, 3, 4, 5 years are going to be a target-rich environment if you are an activist shareholder seeking advantage, because you're just going to start suing companies, right, for areas in which statistically you know that they have fault. So this is going to be kind of like, you know, in the 19th century, you didn't have to mine for diamonds in South Africa. You could just go to certain places and pick them up off the ground. Okay, that was the easy times. That's kind of where this is right now. Yeah,
Is this always gonna be in the Chancery Court in Delaware cases or?
so it is being,
West Coast.
it is spreading out. So there's a little bit of a war, you might say, between different states, okay? So Wyoming, Texas, Nevada, are trying to position themselves as being very pro-business as opposed to pro-shareholder. Delaware is the archetypal pro-shareholder state. It's an unfortunate situation, right? Because what you're really saying is if you go to Texas or Wyoming or whatever, if you're a shareholder of those companies, what are you trying to get away with, right? I mean, it's sort of like it's not so hot, right? What is really interesting is that you don't see this in venture-backed companies because the VCs and the PEs really want that Delaware level playing field where all things are known, right? No surprises, all that kind of stuff. And so you're not seeing a lot of VCs, for example, getting behind companies that are domiciled in Wyoming. It's the first thing they're going to say is love your stuff, want to give you 20 million or whatever it is. Okay, but you're going to first have to move over to Delaware or at least some other similar state, you know, with similar values. Okay, so I actually went through all that. Okay, so another example of this is imagine that you're the CMO and you've been sued, you've been named in a lawsuit, right? And you're spending $100 million of shareholder money every year. And have a very contentious relationship with your CEO and your CFO around what the hell am I getting for all this money and all that kind of stuff, right? And a shareholder or shareholders plural file suit and name you and probably the CRO and a few other folks, right? And you're being deposed by the plaintiff's lawyer. And the plaintiff's lawyer says, so how do you, you're spending a lot of money. So how do you know? What are you doing to ensure, right, that we're getting our money's worth? And you talk about multi-touch attribution and you talk about, all your metrics and all this kind of stuff. And the lawyer says, well, yeah, but you know what, there's problems with some of that. But are you using AI? Well, yeah, we're using AI operationally to, we're doing a lot more for a lot less, money and all this kind of stuff and blah, 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 blah. Yeah, but how do you know it's effective? Well, I don't really, I guess, know that it's effective. It appears to be effective, but we don't know that it's effective. We can't put a dollar number on it. Boom, right there, okay? That's like probably more like strike 1 and 2, right? And then he said, well, what about causal AI, things like that, right? Why are you not using that? Well, that's just not where we are right now. We just haven't figured that out yet. It's over. Okay. So remember, you don't have to have ill will. You don't have to be a bad person, right? Or anything like that at all for you to get just absolutely drilled. So where this is actually really going is that the level of transparency and accountability that we're all going to be subjected to through various forms of AI over the next, say, 3 to 4 years, right, is beyond our ability to comprehend. I talk about it as a zone of ambiguity that we've all had in our lives that we've used to great personal advantage from time to time, right? That zone of ambiguity is never going to go away, but it's going to get a lot smaller over the next several years. And for example, I mean, not to trivialize the momentous, but If you are posting stuff on LinkedIn that's just baseless, you're gonna get called out. Right? Because there's gonna be like a little system in there that LinkedIn's already playing around with that basically says this doesn't actually have any factual basis. So I mean, it's just gonna get really, everything's gonna get tightened up. Now, the cool part about it is that also if what you're doing is really working, if it is really having a demonstrable effect, okay, you are solid gold. There won't be any of the annual conversations that historically we have all been a part of, right? Where you kind of have to re-earn your stripes every year and all that kind of stuff. That's not happening pretty soon. But it's going to be very rigorous, right? So as it says right here, impairment has never been easier to identify or scope. That's going to be like the total truth. Like if you have, so what the case law, what the ruling actually said is that you have to be able to show that you have understood as much as humanly possible the risks that you need to mitigate, the downside risks. And at the same time, you need to be able to show that you are preparing adequately for upside opportunity that might come along, right? So this is actually very much like what Dave Cody at Honeywell used to preach all the time, right? That anyone can manage for the short term and anyone can manage for the long term. But the magic is that you got to do both at the same time.
I love this because you have just connected the dots on something that I hadn't before, because I knew about this ruling. And at the same time, I and my team have been in my consulting capacity and been doing a huge amount of work for a major provider of sort of testing certification services on AI, developing AI risk management processes and certification methodologies. And what this shows is that it's going to increase the demand. I hadn't connected the dots. It's brilliant. Yeah.
Yeah, no,
They will love it.
yeah,
I will go back and tell them tomorrow. Yeah.
Yeah, we actually, I don't know, maybe we should talk. We are launching next month a new company called Fiduciary. That is web-based, customized, LLM-driven education for officers and downstream from officers, so that you can learn all about all of this and what it means specifically in your part of the company. And also, it's going to help you prepare that assessment of risk, right? And what you need to do, and then you can push one big button and file it upstairs with your CFO and your GC and all that kind of stuff. But it is not, it's methodology neutral, right? So it could be a channel for what you're doing.
I think they should definitely, your new company should definitely talk to my clients.
Yeah.
If I can add to this, I think it was a year and a half ago, I presented on the intellectual capital in the boardroom standard. So that did get ratified, and that provides the self-directed framework to determine where in the organization you need this. So, and that was before this, like we were even aware of this ruling going and happening.
Mhm.
So I think what you're trying to kind of do with Fiduciary is that that's the mechanics of it. Right.
We're the platform.
Yeah, exactly. But I think like the mandate, like the self-directed mandate to do it, that actual standard exists, a ratified US standard to go and manage corporations that way. The problem is that I would say until this ruling came out, nobody would have given a damn, which is one of the things we're struggling. Now, not enough people know about the ruling to still give a damn.
Yeah, no, it's been very interesting. So as luck has it, right? A lot of the people that I went to school with ended up being general counsels of larger and large corporations. And And I called them up. This is starting like last summer. And I go, hey, you know, what do you know about this? I describe it and they're like, I don't know what you're talking about, right? And then a couple of them in their best, you know, only slightly condescending way, right? Essentially implied that I must have misunderstood something somewhere along the route on the way. And I said, tell you what, I'm gonna send you by email right now 2 pages, and all it is just links, links and links and links. You pick a link, you click on it, you read that, you tell me what you think, right? And I got so many, oh shit, responses, right? It was just, you know, and like one guy goes, I'm sorry, I gotta let you go. I've got to go yell at my governance law firm for not saying anything to me about this, right? So it is, it's just kind of one of those things that for a variety of different reasons, everybody ignored for a while. But the thing that's always the trigger is when people start filing lawsuits and winning them based on this kind of stuff right here, that's when all of a sudden everything changes. So this idea though of really on this 4th point down here, that officers must show that they're actively mitigating downside risk and preparing for upside opportunity. So reducing negative costs to shareholders without restricting their access to upside, okay, is really, really super key. If you only do half of that, right, and you know, this is almost like, I don't know, it's just total Sunday school reference here, but the parable of the talents, you know, and there was one guy who buried his talent in the ground, right? If that's you in this situation, it's not going to turn out well under Delaware 2023, right? Also, as the company that I was involved with found out, years of data negligence or negligence in some other form, right? The negligence that spurred all this was McDonald's. So this was the original Delaware case, was a case against McDonald's for large scale endemic sexual harassment, where the CHRO was not only not doing anything to stop it, but was actually one of the foremost problem children in the whole thing. And a young associate on the plaintiff's team at the last minute added the CHRO officially to the suit because, well, I think he was probably pretty prescient, but you know, he didn't have any reason under the law to do that. But he just said, oh, what the hell, you know, the judge can always remove him from the suit, right? Well, not only did the judge not remove him, but it actually made that whole extended ruling happen. So you can get hauled back in time under this new fiduciary duty regulation that is you know, to an extent that's, think that there is a cap of like 20 years. Well, so like the California company that had this situation, so a lot of the engineered, which is a kind of a colloquialism, right? That says this should not have happened, but it did, right? A lot of the engineered data from the sales guys in the CRM was they were playing games with like when they declared an opportunity and all this kind of stuff, because if they brought in a deal under a certain timeline, they got a spiff, they got paid more money, right? So now, and there's a lot of this. So now the company has settled with the shareholders, but now the company's got to figure out, do we do the clawbacks on all this, right? How much money is at stake? Do we really want to go through all the pain and agony of this process, right? I mean, it's, you know, there's a lot of mess associated with it. Same thing with M&A, IPO filings, the ripple effects on this could be monstrous, depending on the situation.
Question for you on like operational implications, because I was at P&G when Starbucks had to be implemented. And essentially the kind of like fiduciary governance costs went up materially. Because we now had to close like a month at the quality of a quarter close within 5 days of the month end. We had to close the quarter at fiscal year audit levels, I think within 2 weeks, quarter end. And then we had to be able to close the year, right? So is this essentially, call it like almost like a fiduciary tax on the business? Like you now.
It is, but since most of it will be done by AI,
Okay.
right? I don't think it's gonna be anything like what we saw, because I saw the same thing with SOX 20 years ago, right? I mean, the burden on companies because of SOX was intense, right? Today with AI, it's just not the same, right? It's not the same, but it is going to absolutely accelerate the adoption of a lot of these technologies without a doubt. You'll be so screwed if you can't rattle off all the stuff. Yes, sir.
Yeah, as somebody who spent a fair amount of time with plaintiffs' attorneys, both with them and on the other side of them, I think it's really important to appreciate the difference between a prospective perspective and a retrospective perspective. If AI, or an expert for that matter, real human expert, has access to information that was not accessible at the time a decision was made, it might make a different decision. And so I think what we're going to see are some lawsuits where there is a retrospective AI analysis. And the defense will be, this is where the implications come in, the defense will be that we considered all that was possible to be known that was relevant at the time of the decision.
Yeah.
That's a very high burden. But it says a lot about data collection, data availability, who's involved in the decision making. It will be a pretty dramatic change in governance.
It absolutely, you're 100% correct. I think that on a very broad basis, this is going to be true. Let's just again go back to the CRM situation, right? CRM data quality is known to be so bad in tech, for example, that it's a meme.
Mhm.
It's a joke that people reference,
They need
right?
more Jerry's.
Yeah, right. And so it's one of those things where there's just the plaintiff's lawyer said in this case, look, you obviously have been aware of this, right? But you didn't take it seriously. You just decided without basis, okay, that risk levels of distortion were low enough where it wasn't worth the hassle of investigating, right? Yeah.
I'm gonna keep crossing the questions. By extension here, does this then go, because you said corporate officers, which is different from boards of directors.
Right.
Yeah. So does this apply to a board of directors? Because if you're on the board of a company that is privately held, and then is say doing an IPO or selling itself to a publicly held company where this becomes applicable.
Well, it's applicable to a privately held company as well.
Okay,
So if you're
so
venture backed,
between private transactions, that can be used to essentially convey a misrepresentation on
absolutely,
the part of the seller.
right. That's actually a fundamental issue
Okay,
that comes up.
that makes this actually way bigger than just
Yeah.
looking at 2,800 public listed companies.
Yeah, so if you're thinking that I'm only talking about public companies, let's deal with that right now, okay? You can be a nonprofit in Delaware, okay, and this has full applicability. And one of the things that's really interesting about this, we were talking about this at breakfast, right, is that there's been no pushback from anyone on this ruling. Like, crickets, like nothing, right? So I started asking questions because I'm always interested in why something like that would be in such a highly contentious legal environment like the United States, right? And they're like, well, number one, you can't really be against fiduciary duty. It's like being against motherhood, apple pie, and Chevrolet, right? And number two, if you're a board member or the CEO, you now share all of this with a lot more people, which makes you happy, right? And one guy, he was, I mean, and he's a, you know, he's a governance lawyer, so I mean, he's kind of right in the catbird seat. He's like, he goes, you know, he says, you're gonna see the creation or elevation of roles into officer roles for that exact reason. We're gonna want more people on the hook. Now, as a sidebar, I will tell you this, right? This kind of falls more into the personal professional advice category. But I've discussed this with a lot of lawyers. So if you're an officer, you're going to already be covered by E&O and liability insurance paid for by your company. The problem is that under pressure, the way that the company wants to defend itself and defend you is not necessarily maybe the way you think you ought to be defended, right? And so you're going to need your own policy. Fortunately, not hugely expensive for the most part, right? But you're going to need your own policy, and that opens up optionality for you and things like that. But here's the other little ripple on this, right? So even though agencies, for example, don't have fiduciary duty to their clients in a legal sense, they only have it contractually, have contractual duty to their clients. You can't, if you're the CMO and you have fiduciary duty of oversight, and yet downstream from you, your entire organization hasn't been trained in this, has no understanding of this, right? You're the one hanging out to dry on this situation. So what you're going to see is a lot of fiduciary duty training down much lower in the organization than you probably would have ever dreamed in a million years. And agency or consultancy contracts are going to start to be rewritten with limited fiduciary duties applied, which of course is going to give the agencies and consultancies massive amounts of heartburn. Okay, but it's going to be kind of like one of those why in the road moments. Do you want the work or do you not want the work? If you want the work, then you sign. If you don't, whatever, right?
Mark, that's the time we have.
Okay.
Thank you so much.
You bet. The deck is available. So.